Welcome to Bankruptcy and Debt Relief for Real People. Today I'll go over with you what happens at a Section 341 meeting, commonly called a creditor's meeting in a Chapter 7 bankruptcy. I'm Gary Fraley. I'm a California bankruptcy law specialist located in Sacramento, California. I practice bankruptcy law in Northern and Central California, the Bay Area, and the counties in the Sierra Nevada mountains. However, what I'm going to tell you will be the same no matter where in the United States you happen to be located. What is a Section 341 meeting, a creditor's meeting? This is a question that clients routinely ask me. In every Chapter 7 bankruptcy case, there's a mandatory creditor's meeting. You, and if you're married and filing with your spouse, both must attend. The only exception would be situations beyond your control, such as military deployment or being in the hospital, or the morgue, I guess. Your inconvenience is irrelevant, so don't plan on your vacation until after that meeting is completed. If you cannot appear, your creditor's meeting will be continued, and a new creditor's meeting will be set by the bankruptcy trustee at their convenience. You may have to pay your attorney for extra time and services resulting from you not appearing. If you do not appear at the continued creditor's meeting, the trustee can file a motion to deny you a discharge of your debts. Bankruptcy law requires you to be examined early about your finance by the Chapter 7 trustee. It also allows creditors to ask questions as to your income and assets just as the trustee can. In 99% of the cases, your creditors won't show up. That does not affect their rights in the bankruptcy. In most places, this Section 341 meeting or creditor's meeting will be held at the bankruptcy courthouse. No matter where the creditor's meeting is, the same rules are going to apply. The creditor's meeting is under oath. That means if you lie to the bankruptcy trustee, they also have an audio tape of you lying to them. If you're dishonest in answering the questions, several things can happen to you, none of them good. The possibilities include denial of your discharge, fines, and potential criminal action against you. To put it another way, you can go to prison if you're not 100% honest in your answers. If you hired an attorney, your attorney must be there. However, your attorney cannot speak for you. The attorney is only there to advise you and stop a creditor from being abusive. It is you that must answer all the bankruptcy trustee's questions. The creditor's meeting is not a court hearing, and the individual presiding over that meeting is a Chapter 7 trustee, not a judge. These people are under contract with the United States Trustee's Office to review your paperwork and interview you. Usually the typical 341 meeting has approximately 10 cases for an hour. The Chapter 7 trustee will explain the process at the start of the meeting. However, you must have read the bankruptcy information pamphlet that you will get, which explains the different forms of bankruptcy before your case is called. The trustee will ask you if read it before the trustee will even proceed with your examination. You'll be required to provide a valid government-issued photo identification document, such as a driver's license, passport, or military ID. This is the same ID that you'll have to enter a federal courthouse. You also must have a valid Social Security card issued by the Social Security Administration. Anything less than that little blue card, you don't win the game. You have to have it. If you do not have a government-issued Social Security card, you should immediately go to the Social Security Administration office or online or whatever and request a replacement Social Security card. It usually takes several weeks to obtain a replacement Social Security card. Therefore, you need to do it well before filing of your bankruptcy, or you may be required to return to another creditor's meeting to provide the trustee an original of that document. There's no better time to do this than now. If requested by a Chapter 7 trustee, you must have provided to the trustee copies of the last 6 months of your bank account statements, every pay advice for the 6 months before the case is filed, and your last 2 tax returns. If you've not filed tax returns because they're not required, you have to be ready to explain that to the Chapter 7 trustee. These must be in the trustee's hands at least 7 days before your hearing. If you have not filed all of your last 5 years of tax returns, and you were supposed to, you'll be required to file them before you can get a discharge wiping out your debts. When your case is called, you and your your attorney will come forward and provide the Chapter 7 trustee with your government-issued photo ID and Social Security card. The Chapter 7 trustee will then swear you in. The typical questions asked by the Chapter 7 trustee are something really tough. Your name, your home address. Usually the trustee will request either the first few digits of your address, or they will just confirm that your address has not changed since the filing of your case. Whether or not you have ever filed bankruptcy before. Whether you had your attorney prepare your bankruptcy. If you did not have an attorney, who helped you prepare your bankruptcy documents? Whether you read your bankruptcy paperwork before you signed them. Whether the bankruptcy court documents were filled out completely when you signed them. Were the papers true and correct at the time the paperwork was filed with the bankruptcy court? Whether you listed everything you own or have any rights in whatsoever. That would include rights to an inheritance for the individuals already passed. That would also include rights to sue anyone, even relatives, even if you're not going to, and houses and other assets located anywhere in the world, not just in the United States. Whether you've listed every debt you owe, including debts to friends and relatives, and anyone that thinks you might owe them money or assets, even if you don't agree. Do you have rights to sue anyone? Or does anyone owe you money? Whether you've paid or gave anything to friends or relatives in the last year or 2 years based on state fraudulent transfer laws. Whether you listed all your income, no matter where the income comes from. That includes funds you get as gifts or income under the table to avoid taxes. That includes this year, last year, and the year before that. Whether you listed all your living expenses in the bankruptcy. Whether there's going to be a significant change in your income. The tax returns that you gave the trustee a copy of were an exact copy of your filed tax returns. Whether you transferred anything worth $600 or more in the last 2 years. If so, what did you transfer? What was it worth? And what did you get for those transfers? Whether you're expecting or entitled to an inheritance, even if it happens that the basis for entitling happens within the 180 days after the day you filed bankruptcy. Even if receiving that inheritance or whatever is going to be outside of that 180-day window. You'll be asked if you have any child or spousal support, ongoing payments, and if you're behind. These questions and any others asked of you all need to be answered completely and honestly. There's an old saying, there's no but in the word all. I know it's old because I came up with it in 1978. The good news, assuming you've been completely honest in the information provided to your bankruptcy attorney and the trustee, and you've provided all the documents required, it is likely the only time you'll have to go to a Section 341 meeting or go to a courthouse at all. The trustee can ask you about how you valued things that you might own or have rights in. In most cases, that's not going to happen. However, if the trustee thinks you have something that you have undervalued, such as a home, and they think that asset is not protected or a portion of it is not protected, they can take and sell the non-exempt items to get cash to pay creditors some or all of your debts. I regularly have clients that have told me when they left their creditors meeting, gee, I didn't believe you that it was going to be that easy. That wasn't bad at all. If you want to find a highly qualified California bankruptcy attorney, go to the California State Bar Legal Specialization webpage. You can then enter bankruptcy and the county you live. That will get you those few attorneys the State Bar thinks are the best in the field. For perspective, less than 0.1% of attorneys are California State Bar certified bankruptcy law specialists. I'm Gary Ray Fraley, a California Bar certified bankruptcy law specialist. I've been representing consumers and business clients in California for over 43 years. I hope this information helps you know what to expect when you go to your creditors meeting. To find out more about my law firm, you can go to Sacramento Bankruptcy Attorneys, plural.com. That is Sacramento Bankruptcy Attorneys with the S.com. To schedule a consultation with me or my associate attorney, call my office at 916-485-5444. That's 916-485-5444. Or go to my SacramentoBankruptcyAttorneys.com webpage and fill out the request for consultation form in the upper right-hand corner. You can also click on the homepage just above the video and get my free book, 49 Do's and Don'ts When Considering Bankruptcy. It is written for real people, not attorneys, and has a bit of my quirky humor in it. I promise you that it is a fun read despite the fact that you'll learn a lot about bankruptcy pitfalls. Any book with a preface quoting Alice in Wonderland has to have some humor in it. If you found this video helpful, please give it a thumbs up and share it with as many people as possible who may need bankruptcy but are afraid of the process and seeing an attorney. Please click the subscribe box below on the right-hand side of the video. That way you can get my next video on bankruptcy law and process. This is Gary Fraley signing off for now. Look forward to you joining me for my next video. Have a wonderful day.